The increasing size of awards of compensation being made under international investment treaties is drawing greater scrutiny on the approaches that international investment tribunals use to arrive at these sometimes staggering amounts. One question that's being asked is, how are things being done elsewhere? A forthcoming IISD paper seeks to answer this question by taking a comparative lens and looking at approaches to the awards of compensation being used in international property law cases heard before other international courts and tribunals. This includes the Permanent Court of International Justice, the International Court of Justice, and the European Court of Human Rights, amongst others. During this preview video, Esme Sherlow, an associate professor at the Australian National University and the paper's lead author, will draw out some of the novel and innovative approaches being used by these international courts and tribunals when awarding compensation. By contrasting these approaches to the approaches used by international investment tribunals, the forthcoming paper will seek to draw out some key policy considerations for the fundamental reform of compensation principles used in the international investment treaty arbitration space. So Esme, what are the aims of the paper?
So the paper picks up from previous IISD work that looked at approaches that investment tribunals take to awarding compensation. And the paper that IISD previously produced on that topic suggested that the practice of investment tribunals differs from that of other international courts and tribunals. And so really, this paper's purpose is to investigate that in more detail. And to do so, the paper examines the approaches adopted by 6 different international courts and tribunals to assessing claims for reparations and specifically to compensation in claims that are broadly analogous to investor-state disputes. That is, claims that involve allegations that a state has interfered with an individual's private property rights. And so we look at a range of different international courts and tribunals to look at their comparative practice to compensation. We look at some of the very early international courts and tribunals like the Permanent Court of International Justice and the International Court of Justice, as well as regional courts like the European Court of Human Rights, the Inter-American Court of Human Rights, and the African Court on Human and People's Rights. And then also the practice of more specialised regimes like the International Tribunal for the Law of the Sea. And really what we're hoping to do in this paper is draw out how each of these international courts and tribunals have analysed claims to compensation in international private property cases, looking at how they converge in their practice as amongst one another, but also potentially as against the practice of investment tribunals, but also what differences or innovations their practice shows and the extent to which that might be relevant to spurring innovations in other regimes through reform processes like what is happening in investment arbitration.
What stood out to you about some of the approaches that you identified?
So I guess one of the first things that stood out was how each of these international courts and tribunals has largely adopted the standard for reparations that applies under customary international law. So most of them have endorsed a view that a breach of an international obligation that protects an individual's private property rights will entail a requirement on the breaching state to provide full reparation for any loss arising from that breach. And this is the case even where particular international courts or tribunals are working by reference to potentially different language around reparations that's contained in their treaty. And examples of that would be the African Court and the Inter-American Court, where the relevant treaty states that any breach of the treaty will occasion a requirement to make remedy, including a requirement to provide reparation and fair compensation. And despite that slightly different language, both of those courts have endorsed a view that the compensation required, or the remedies holistically required for any breach, have to meet that standard of full reparation. So one of the interesting findings is that most of these international courts and tribunals are working by reference to a very similar overarching principle that a breach of international law will entail a requirement to make full reparation. Another really interesting finding is the tendency of international courts and tribunals to award remedies in the form of restitution out of preference to other forms of relief like compensation. And that comes from that full reparation standard under customary international law. But really, it also links to the institutional structures of the courts that we investigate in the paper. Most of them, or all of them, are standing courts with a fairly robust institutional structure, which means that any awards of restitutionary relief can usually be enforced by the court or by the political body in the particular regime that can oversee compliance with the judgment. And you can see how that might differ, for example, from an award of restitutionary relief in a more ad hoc regime, where once the decision maker makes its decision, it's functus officio, and it has no enduring powers of assessing compliance with the award, in which case compensation or more one-off forms of relief might be preferred over, say, a requirement to make restitution. Another interesting feature arising out of this review of the practice of international courts and tribunals is the tendency of many of them to resort to equitable principles to value loss. And that includes the valuation of loss for both material and non-material damage. So many of these international courts and tribunals are resorting to equitable approaches, which they describe really as kind of a balance of considerations and fairness approach in order to evaluate the loss of individuals who've had their private property rights interfered with. And often that means that these international courts and tribunals are exercising significant degrees of discretion in setting the appropriate amount of compensation for any damage from a breach of international law. And typically this will result in lower awards of compensation than you might see in a regime like investment arbitration. But it also means that the courts and tribunals aren't necessarily bound by the evidence that's submitted by the parties. They're instead considering all of the factual circumstances surrounding a given breach, including, in some cases, the state's own contextual circumstances and the nature of the breach at issue.
What lessons do you think could be drawn from this comparative research for those looking to develop new treaty language or institutional reforms to address the way that international investment tribunals are approaching the award of compensation?
So I guess one of the really important aims of this paper is to highlight that very different approaches exist amongst international courts and tribunals to issues of compensation. And those different approaches might provide inspiration or even warning stories in considering how one particular international adjudicative regime could be reformed in order to change its approaches to compensation. Interestingly, as I flagged, many of these international courts and tribunals are working by reference to a similar standard for assessing remedies under international law, the standard of full reparation. But those rules of customary international law will apply where states don't themselves in their treaties stipulate more specific approaches. So actually states have quite a lot of discretion in treaties to adopt provisions directing international courts or tribunals to adopt particular approaches. Of course, they should be very specific in doing so and think through as well how to flag that specific approach differs in some material way from the customary international law standard if they're looking to move away from that customary international law standard. But they do have that flexibility to craft their own approaches for particular adjudicative regimes. They might also want to craft more specific approaches to kind of influence how the full reparation standard, even if it is applied, is then interpreted in practice. So one of the interesting findings out of this comparative study is that many international courts and tribunals are actually using court-appointed experts to assess what compensation should be provided to applicants in any given case. And that, of course, differs, say, from the heavy reliance on party-appointed experts in the investment context. And it really highlights that a reform process is very integrated. So reforms to some procedures are going to influence arbitral approaches to other issues. And so thinking about, for example, procedural powers of an international court or tribunal and whether those procedural powers permit the court or tribunal to make use of court-appointed experts and in what circumstances, and then how the role of those court-appointed experts is managed is one really interesting way of kind of coming at the compensation issue from a slightly different perspective, focusing on the role of the tribunal in appointing experts or having access to tribunal-sourced evidence. Equally, many of these other international courts or tribunals are much more integrated with domestic processes, and so often they will work in a complementary fashion to domestic processes, including by referring questions of compensation back to domestic mechanisms for determination.
Thank you so much, Esme, for your time. And for those of you interested in this issue and looking for new ideas for reform to the ways in which investment tribunals approach the crucial issue of compensation, please stay tuned for the forthcoming IISD paper on this topic, authored by Esme, which will be coming out very soon.